is Marc Randazza and Jordan Rushie.
Good morning, Senators.
Good morning.
Thank you for taking the time to address this very important issue. I'm here with my co-counsel, Marc Randazza, wearing many hats in support of SB 1095. First of all, I'm here as a First Amendment attorney, currently defending the Northern Liberties Neighbors Association, its president, Matt Rubin, and Christopher Sawyer in a SLAPP suit, and you'll hear more from Matt Rubin of the Northern Liberties Neighbors Association in a second. I'm also a member of the Pennsylvania Bar Association Civil and Equal Rights Committee and Civil Litigation, who has not yet taken a position on SB 1095, but we intend to. I'm also here in support of the bill as Vice President of the Fishtown Neighbors Association, which I believe in Senator Farnese's district. You're going to hear from Mr. Randazza, who is an authority on anti-SLAPP statutes across the country, who's going to give some of his views and try and add what we can add to this bill to make it effective for us litigators that are in the trenches every day. Thank you.
Thank you very much for having me here. I was delighted to hear that Pennsylvania was considering an anti-SLAPP statute. The ghosts of the founders are smiling on you today. I started with anti-SLAPP litigation when I was a baby lawyer, back then full of idealism and full of vigor for my client, and I was up against a very large law firm, and I was from what my adversary called a pissant two-guy law firm that couldn't possibly beat them. Well, we did. After 15 months of litigation, and I was so proud to tell my client, hey, we won. And my client looked at me dejectedly and said, if we won, then why is my retirement fund empty? Now, unfortunately, this was in Florida that did not have an anti-SLAPP statute. I practice nationwide. I'm licensed in Florida, Massachusetts, Arizona, California, Nevada, and I have seen the different experiences that litigants have in states with or without anti-SLAPP statutes, both in litigation and in even seeking counsel. I frequently get the call when one of these cases is filed somewhere, and I can't do them all. And when I get one that's in, say, Washington, Oregon, California, a place with a strong anti-SLAPP statute, when I put the word out that I need some co-counsel or I need someone just to take the case, people are falling over themselves to help these people, often on a pro bono basis because they know that they can recover their fees from the plaintiff. When it's Arizona or Florida or someplace like that, I hear crickets, and often it's if I take the case at all, the person is poorly funded and unable to defend themselves. That's really not good when you have a profound national commitment to wide open and robust debate, but that debate will be stifled by the mere inability of a litigant to get counsel, let alone the punishment that they feel after litigating this case forever, however long it takes. I had a case in Arizona where I had a party that was sued over a consumer review. Now, this wouldn't be covered under your current statute and your proposed bill, but this is still a matter of public concern. Consumer reviews are extremely important, and we can't have a functioning economy or a society without being able to comment on commerce. And it was clearly frivolous. It was just this company wanted this debate stifled, wanted this review gone, and in the end, my client had to surrender in that case. I am a First Amendment advocate. I'm an officer in the First Amendment Lawyers Association, and it saddens me how many times I'm just making the patient comfortable as we surrender these cases, because I have to be very honest with them and tell them about that first anti-SLAPP case that I had where the client said, this is great, I get to live forever. There's two ways to make sure that you're immortal. You get a disease or a case named after you. Neither one is good. So I think there are a few provisions that I'd like to suggest. I was instrumental in drafting the Nevada anti-SLAPP statute, which we are very proud of. Has no case law yet to look at because the only time it has been used so far is in an ongoing case that I have going right now. But I think if you look at the West Coast states, you get some of the best language and the best experience that you can draw from. I'd like to echo, but not spend too much time on it, that you should make it more clear that this applies to all speech on matters of public concern. There are anti-SLAPP laws in most states, but most of them are so limited that I really only consider Washington, Oregon, California, Texas, and Nevada, and DC to have real anti-SLAPP laws. The rest of them, when it's so narrow, if it isn't exactly aimed at procuring a legislative result, you wind up with a litigant that has no shelter at all. I'd also like you to take a look at the special motion to strike issue that my colleague here brought up. Correct. I think that is the best way to deal with these cases, because you want this to end quickly. You want a judicial determination early on. There's also a change that I'd like to suggest where this bill calls for immunity from liability, not immunity from suit. Now, that seems to be a very small semantic change, but there was a case involving the Oregon anti-SLAPP statute, Englert versus McDonnell, 551 F. 3rd 1099 in the Ninth Circuit. And Oregon had this infirmity in its statute. Well, why that's important is that it provided for an immediate interlocutory appeal. Otherwise, Oregon litigants, before they changed their law to deal with this problem, if you lost that motion at the trial level, you could later on appeal it. But again, if we're talking about trying to protect people from long, drawn-out litigation, do we really want to have them go through 3 years of litigation, then appeal to an appellate court, and then finally have the appellate court say, yeah, you were right all along? Not many people are going to be able to withstand that. So I would strongly suggest you make this an immunity from suit, not immunity from liability statute. Also, on page 6, line 11, there's a one word here that I'd like to suggest you take out, which is solely. If it is, Illinois had an anti-SLAPP statute that had that language in it, and it really was a beautiful statute. None of us saw this detail in it except when the Illinois Supreme Court finally saw it. It limited its statute so narrowly that essentially you needed a smoking gun communication from the plaintiff saying, I intend to violate the anti-SLAPP statute. So if you look at Illinois statute, it's pretty good, but it's meaningless now. So I would encourage you to learn from Illinois' mistake and remove that. I would also echo the voices that have called for statutory damages and mandatory fees, not discretionary fees. I think if you have some kind of statutory damage, I don't necessarily like the way that Nevada wound up compromising on it because it's up to $10,000. I think sometimes you may need to have the judge's discretion to look at what will actually deter this from happening again, because to some of the plaintiffs that I've been up against in anti-SLAPP motions, $10,000 is really just the cost of doing business. It would be well worth it to them to pay that and then file the next one again. I'd also like to suggest that in your legislative findings that you do note that you're looking toward the West Coast states, simply because you're going to have a new anti-SLAPP statute here that the first judge who gets a hold of it could tend to steer the direction of where you're trying to get this thing to go in another direction. If you look at when we passed it in Nevada, we made sure that the Nevada legislature put in its findings that we should look to case law in California, Washington, and Oregon until case law is developed in that state. There's already such a broad and well-contoured amount of case law there that I think you would be better off following that, since you are simply following the spirit of those laws anyway. Why not follow that judicial history as well? Another suggestion I have two more suggestions. One, perhaps I might get a little bit of dissent from the people who are normally on my side, but the first one is a bond procedure. Sometime in California, they have a civil code procedure that you can require a plaintiff in a case like this to post a bond. I think that would be helpful, because I defended one case in Florida, which, as I mentioned, has such an exceedingly narrow anti-SLAPP statute that it's virtually useless. I handled the one case in which it was useful. I just got lightning struck. We got a $187,000 judgment against the plaintiff, which immediately went bankrupt, and then my client was left holding the bag. So we have a very nice piece of paper that says that they were wrong, but no real justice there. Finally, These statutes are very dear to my heart. This is a very important thing for you to do. However, I think you should recognize the possibility that it can be abused. And California was forced to pass 425.17, which is its slapback provision. I think Oregon has one. I know Washington has one, and I know that we wrote one in Nevada. I think that it should be very narrow. What we did in Nevada was we said if it was brought frivolously or vexatiously, then the prevailing party would be entitled to fees on that. Because what you do not want to do is write this wonderful, glowing bill that protects First Amendment rights, but then wind up finding in a few months that you have actually limited the rights of certain justifiable suits to go forward. I am no stranger to bringing plaintiff side defamation suits, and I'm not afraid to do them in states that have anti-SLAPP statutes. So I think if you look at the Nevada statute, it's Nevada revised statutes 41.660 to 41.670. We've got some good language in there that I would encourage you to look at and to import. But the one thing I'd like to see you maybe not take from that is the very limited statutory damages provision. Thank you.
Okay. Senator Randazza, would you have some questions?
Sure. Thank you to all the first set of testifiers. It's been very helpful. I'll just start off with Professor Karras. Are you able to discuss in greater detail your experience as an expert witness in the SLAPP case in New Jersey that you referenced in your testimony?
Sure. It really is a very typical case, I believe. There was a developer of a mall-type facility, and it was going to border on some residential areas. This was in central New Jersey. And community groups right away started meeting, wondering what to do about it. They didn't like it. They didn't like the traffic, the parking, the big commercial buildings next to their residential neighborhood. So these are just ordinary citizens concerned, about their quality of life in their neighborhood. So they began speaking out. They went to different boards to complain, zoning, things like that. Really whatever they could find to try to get a handle on a way to stop this, if it was at all possible. And the developer hit them with a suit that is almost, I have to say, a parody of a SLAPP. It had several counts. Each count asked for $1 million. And they were every single count alleged conduct that was protected by the First Amendment of the United States Constitution. So it asked for a liability of $1 million, and it made them cumulative. So they said they wanted $7 million for speaking out in a way that was protected by free speech.
Thank you. Also, maybe I have a question that I was going to submit it to Andy, but maybe the news media may be a little bit more akin to that. So I guess my question would be, number one, in the litigations that you referenced and you've seen, does the SLAPP defendant often get named in those suits as well? And anybody that's actually had reference to those litigations might be able to sort of comment. So I'll just throw it open to the panel. Again, the question would be, does counsel to a SLAPP defendant, the counsel, often get named in those suits as well?
It happens. I mean, no, I wouldn't say it's all the time, but yeah, it certainly happens.
Okay. And my other question would be, do you know if insurance premiums have been rewarded as damages to prevailing parties in SLAPP litigation?
I haven't seen it.
Okay. Anybody seen that before?
Insurance policies being used to defend against the SLAPP?
Well, if the premiums have been rewarded as damages.
No, I have seen a defendant
The defendant, oh, yeah.
have a homeowner's policy that sometimes homeowners' policies cover you're getting sued for all sorts of things. And I know of at least one instance where it included a SLAPP.
Okay.
I think it's a different question than what you were asking.
Right.
Yeah, on the defense side, certainly, but not on the plaintiff side. But back to your earlier question, about the attorneys being named.
Right.
I actually have been involved in a case in Nevada where a party has not only sued the attorneys involved in order to try to cause a division between the parties and their attorneys, but also has now named the judge, as well as 7. I mean, of course, they're also naming I think the director of Homeland Security, the New York Times, Forbes. But you know, it's in this one case, it's probably I think it's a 385-page complaint that can only be described as insane. And the litigation has, unfortunately, it was filed before the Anti-Slapp law was enacted. So that litigation's about 14 months old at this point. Pretty soon, I imagine the way that litigant is going, it'll be old enough to vote one day. So, you know, this is this kind of thing can, you know, even when it is a patently frivolous case, these things can go on and on and on without this kind of important legislation.
And just one final question, if I can, Mr. Chairman. To the Pennsylvania News Media Association, have news outlets and members of the press been sued for merely reporting or printing articles that have included publicly available information or quotes from individuals that have been interviewed? Have you seen instances like that?
It's not unusual to hear that kind of thing on our hotline. We'll say, as far as the specific litigation goes, they would retain outside counsel who would litigate a case. So I can't comment on specifics, but it's not unusual for us to hear that kind of a concern from our members during their pre-publication review. Can I be sued for this if we publish it? Is there risk here? It's not unusual for me to get calls on my legal hotline where a reporter will say, this is what was said, as you know, a citizen activist stood up at a public meeting, this is what was said, we think it's potentially defamatory, could we be sued for this? The answer is yes, you could be. Now, whether or not that has actually resulted in litigation, I can't tell you specifically today, but it's not that concern is common.
And just to follow up, I mean, we have trouble here in Pennsylvania simply because our SLAPP statute is so narrow at this time, but in other states, based on our research, newspaper publishers, columnists, editors, the Rolling Stone magazine, I mean, many media outlets from small weekly publications all the way up to national magazines, as well as the San Francisco Chronicle, have all been defendants in SLAPP suits. And in most of these cases, it is because of their reporting on a topic of public concern. And also, as Ms. Molesky mentioned, a citizen activist is asking a government body or asking for help or protesting. The newspaper columnist, editor, reporter then follows up with that. And they often are drawn into these suits. And that's why we feel a keen interest from our association and our members in making sure that this kind of legislation is broadened so that our members can take advantage of the special motion to strike and other provisions.
I think one of the interesting points that sort of has come up is the internet and how a lot of folks today just get their news media. It's no longer in the paper, and years ago it was the internet, but now it's almost social media, Twitter, or folks are getting their information in 140 characters. So do you see an upswing in the suits as more folks begin to use the internet as literally the source for news and media coverage? And does that have an effect on the? And do you think there's anything we can do to sort of prepare for that as we sort of fashion the bill?
I'll just jump in. Here in Pennsylvania, we actually have a very strong print market, but so many of our readers here in Pennsylvania consume news still the traditional way of print, but also online. However, nationally, there is research and scholarship, and perhaps the professor knows more about this, but one of our colleagues at Penn State University, Professor Bob Richards, recently wrote a paper that discussed cyber SLAPP. So that's a topic beyond what we have on the table here today, but just the 30-second summary, a cyber SLAPP suit, as I understand his scholarship, gets into some of those online issues.
And it's not unusual for our members, many of them have online presences, and it's not unusual for them to have their online coverage be the source of a complaint from a reader or their attorney.
Yeah, I mean, in my practice, I don't just defend journalists, but regular people who find themselves victims of these kinds of suits. As I mentioned, the consumer review on Yelp. But I also represent a number of websites that host consumer reviews. In fact, I've represented Yelp, represented Avvo, the lawyer rating service. And these companies are not producing traditional journalism. But, you know, this 10 years ago, only a small segment of us were on the internet. Now, I mean, I think you find even homeless people have some access to the internet, and I don't even say that out of levity. I mean, they do. You can find somebody homeless with a blog. Everybody's got a Facebook page. Every single one of the citizens in your districts could make a comment that could wind them up in court. You know, I represented a guy who simply posted a tweet that spoke about a Hyundai dealership, and he said, this Hyundai dealership sucks. That's all he said. Found himself staring down the barrel of a very expensive lawsuit. We had, I represented a number of parties, including the Philly Law blog published by Mr. Rushie. This is how we met. I wound up representing him. There was a case in which, in Washington, D.C., where an attorney, his law license was 3 days old, took on a capital murder trial, which, yeah, I can see by the expressions on your faces already, you probably would say that there's something wrong with this. Did not handle it very well, and the judge admonished him and said that he was declaring a mistrial because of the degree of incompetence shown. Well, this is on the record, in court. The Washington Post wrote about it. They got sued. Every blogger that wrote about it, everyone who commented about it, I think there were 82 defendants and 88 defendants. I had 35 attorneys as my clients, so for that alone, I am sure to spend time in heaven. But if you imagine representing 35 lawyers at the same time. But that in that case, all of these people were embroiled in litigation for more than a year and a half because this took place in New York without the protections of an anti-Slapp law. So yeah, it's not just, you're definitely going to be doing a big favor for the traditional media, which you should, because without them we don't have a functioning democracy, but we also don't have that if your average citizen doesn't find themselves protected as well.
And I would just add one thing to that is Pennsylvania law is incredibly plaintiff-friendly right now. One of the cases that's always perplexed me is a case called Bicchetto versus Gibson. And Gibson was an attorney that sued another attorney named Bicchetto for defamation. The legal intelligencer asked Mr. Gibson for a copy of the complaint. He faxed a copy of the complaint over to the legal intelligencer, and he was sued by Bicchetto. And they used what's called a theory of, they called it overpublication. And the Supreme Court actually upheld that merely republishing a legal document to the media could constitute defamation. And I think it's created some very dangerous case law, especially when you consider that all of the pleadings in a federal court are going to be available online through PACER. All the pleadings in Philadelphia State Court right now, I can get them online. But right now we have a case out there, and it was recently cited by Judge Bernstein of the Philadelphia Court of Common Pleas that says in Pennsylvania right now, simply over-publicizing a court document can expose you to liability, and that's scary.
Would this legislation help you in that?
Possibly. I think what I would ask you senators to do would be to expressly, and this is just my personal opinion, to overturn Bicchetto versus Gibson, and that you don't recognize a tort of overpublication.
So that's another issue.
But that's another. Yeah.
I've got a lot on it, but interesting comment though. I just have a couple of questions, and maybe not even relevant, but I'm trying to get an understanding of this and where the boundaries are and whether we should have boundaries. The last comment you made is one of the things that I was thinking about, is that how do we not discourage legitimate suits, and how do we do that? I mean, what you're saying here is important, that we don't want frivolous, unfounded complaints filed against people who are exercising their right of freedom of speech. Right. Okay, that's clear. But then how do we avoid the unintended consequences? And I've been in the legislature long enough, and we've done all that many, many times at every level of government. We pass a bill, sounds really good, and there's all kinds of unintended consequences.
This is
And
something.
how do I
that-
avoid that? How do I avoid that before we report this bill
Well,
out of
that's the slapback provision that I think any slap suit, if it doesn't have it, it's probably destined to be very unpopular at some point. And what you put in it is, I would follow Nevada's language. Nevada's language is very.
You had a section there?
Very refined. 441, I'm sorry, it's Nevada Revised Statute 41, 660 to 670. I think it's, 670. Or if you look at California's 425.17. 425.16 is its anti-slap, 425.17 is its slapback. And what you have there is language that I would not make it too broad. I'd say if it's frivolous, or if you bring an anti-slap motion frivolously or vexatiously, then you should be subject to sanctions and fees as well. That has proved to be a pretty good backstop, and it has not shown. I haven't seen a drop-off in legitimate defamation complaints filed in jurisdictions that have anti-slap statutes. In fact, I sometimes get retained, although I defend 95% of these cases that I do, I'm defense counsel. I do occasionally get calls from plaintiffs' counsel who say, we'd like to retain you to conflict you out, and please give us some advice on how not to mess this up. And the first conversation we have is, well, if I think your case is a little bit weak, make sure you do it in a jurisdiction without an anti-slap statute. But if your case is strong, I think you're almost better off bringing it in one, because it's already shown that you have put, as a plaintiff's lawyer, you have put thought into the fact that you know that you can get hit if this is frivolous. You know that you can get hit if this does not have a substantial likelihood of success. So in my experience, the only cases I've signed on to in order to be counsel of record in a plaintiff's case, with the exception of one, have been in states with active and strong anti-slap statutes.
Just one additional thing on this. I think you need to be aware of this problem for sure, but there is a trade-off here. I mean, you have to decide whether the First Amendment and free speech are important enough to us to carve out what would otherwise be successful or potentially successful civil lawsuits based on private torts. And the authority in the Supreme Court of the United States is all with you on that. It's not a conservative majority or a liberal majority. It's been going on for 40, 50 years. But there is a trade-off. So I think it's a good one, and you can use the caution just suggested to you to make that clear.
Okay. I have some other questions then on that. I mean, this is not an oppose or against the legislation. I just want information, because these are questions that are going through my mind. That is, then are we creating an immunity in a particular type of individual for a particular type of suit here? And is that good policy unless we have some provision in it about slapback or some other? How do we avoid that? Do we want to?
Yeah.
Is that in effect what we're doing? Is creating an immunity?
Norm Pennington talks about it as an immunity in the antitrust area, and almost as if it's absolute, like there can't be any negative legal consequences from petitioning, particularly to government. I don't think you're doing more what I would see as a balance of what you have here. You're not saying it's absolute.
But does this include, I guess it doesn't, but just to quote, what it does not include, public officials. I know, for example, township commissioners and supervisors. I've heard from them that they frequently get sued over issues on development, and they can't even speak out for their constituents. Now they're told not to do that because they're a quasi-judicial official. It may not be covering, I guess this doesn't cover that, but is that, you have any experience in that area? And this is not what we're talking about with this legislation.
No, I have not handled a case like that before.
Okay. I have seen slap suits brought by government officials, which is in the initial book, the Pring and Canaan, they call it the ultimate slap, when the government official is trying to shut up their critics from petitioning to the government.
And this is, we actually raised this issue in the Northern Liberties case, and I'll talk about it very, very briefly. One of the arguments that we tried to make is the meeting of a civic association should be judicially privileged the same way that, something in a deposition would be. And we lost on that issue in the Eastern District of Pennsylvania.
Okay, well, thank you so much. Thank you for your information. It's been very, very helpful.